Usually when we talk about a crime like burglary, there's this expectation of really obvious physical boundaries.
Oh, absolutely. It's almost cinematic, right?
Yeah, exactly. You picture this masked figure in the dead of night, prying open a window with a crowbar, glass shattering everywhere.
Right, the classic movie scene.
Right. And the line between legal and illegal feels as clear as that broken window. You're either outside where you belong, or you've violently forced your way inside.
And we want that physical boundary. I mean, it makes us feel secure in our homes.
Exactly. But today, in this deep dive, we are stepping into the strict legal definitions of burglary. And specifically, we're focusing on the element of breaking.
Which is where those comforting boundaries get incredibly murky.
They really do. Because, what happens when someone commits a crime inside a house they complete permission to be in?
That's the big question.
Right. If you give someone a key, welcome them inside, and then they betray you and steal your stuff, did they legally break in? That is the exact legal problem we're unpacking for you today.
And to do that properly, we are going to carefully dissect the legal doctrine of breaking within burglary.
Sounds good.
We're going to look at the difference between actual and constructive breaking, examine the really critical requirement of the occupier's will, and then explore a specific exception for servants and caretakers.
Because the goal here is to map out these boundaries so you can clearly spot the difference between like a simple betrayal of trust and the capital offense of burglary. Let's start with the foundation. Based on the source text, how exactly does the law define the concept of breaking as an element of burglary?
Well, the general rule is quite strict. To support a conviction of burglary, there must be a breaking.
Okay.
This breaking can be either actual or constructive, but it absolutely must result in an entrance contrary to the will of the occupier of the house.
Okay, so the will of the occupier, meaning your permission as the person who lives there, does a massive amount of the heavy lifting. Can you explicitly identify the elements of this general rule for us?
Certainly. Let's break it down into 4 distinct parts. First, an entrance is affected. Basically, someone actually gets inside.
Right. Thanks, Seth.
Second, the entrance is achieved via actual breaking, which is the application of physical force, however slight. Or it's constructive breaking, involving an entrance obtained by a threat of violence, by fraud, or by conspiracy.
Wait, so constructive breaking isn't about, physically dismantling a door frame? It's psychological.
Precisely. If I knock and say, I'm the gas inspector and you let me in, my fraud constructively broke your legal threshold.
Oh, wow. Okay, what's next?
Third, the entrance must be contrary to the will of the occupier. And fourth, there is an exception element.
An exception.
Yeah. If the entrant is a servant, a caretaker, or someone with the bare charge of the premises, they commit burglary if they enter with a previously formed design to commit a felony.
That exception for caretakers is fascinating. It implies the law treats your hired help differently than your friends.
It absolutely does.
But to see just how messy this gets, we have to look at a wild case from 1922. Let's analyze Davis v. Commonwealth. First, what are the legally dispositive facts?
So Annie Davis was indicted for burglary, for breaking and entering the dwelling house of EP folks in the nighttime, and stealing $412 belonging to Della Wingfield.
I just want to pause and say that over $400 in 1922 was a lot of money.
Oh, a massive amount. But here is the twist. Davis was an intimate friend of both Folks and Wingfield.
Okay.
With their consent, she carried a key, she ate and slept there at will, and she was treated, quote, the same as home folks. Her right to enter was as free and unlimited as the owner's.
So she had totally free reign, and what was the core legal issue?
The issue was, did Annie Davis break and enter the house within the meaning of burglary when she used her key to enter a premises where she had unrestricted, voluntary consent to be?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The black-letter rule is that a conviction for burglary requires a breaking that results in an entrance contrary to the will of the occupier.
Got it.
The rule has 3 testable elements. First, was there a constructive breaking? Second, was there an actual breaking? And third, was the entrance contrary to the will of the occupier, or does the servant exception apply?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, constructive breaking?
Okay, looking at the sub-issue, did Davis constructively break in? The sub-rule states constructive breaking requires entrance obtained by threat of violence, fraud, or conspiracy.
Right.
Applying the facts, there were no threats, fraud, or conspiracy used by Davis. She simply used her key. So the conclusion is the first element, constructive breaking, is not met.
Understood. Now, what about the second element, actual breaking?
For the sub-issue, did Davis commit an actual breaking? The sub-rule is that actual breaking involves the application of some force, slight though it may be, like pushing open a door or turning a key.
Even just turning a key.
Yes. And applying that, Davis did turn a key and push open the door. So the conclusion is that the physical act of actual breaking is present.
Wait, turning a legally given key counts as the physical force of breaking. I mean, I break into my own house every day then.
You do, physically speaking. And that brings us to the crucial qualifying element, the occupier's will.
Right. And what about the third element, that the entrance must be contrary to the will of the occupier, including the servant exception?
The sum-issue is, was her entry contrary to the occupier's will, or does she fall under the servant exception?
Okay.
The sub-rule is that a breaking must be contrary to the occupier's will. A servant or caretaker with bare charge who enters with premeditated felonious intent is guilty of burglary.
How does that apply to Annie Davis?
While applying the facts, Davis was not a servant or carekeeper with a bare charge. She was an intimate friend with free, unrestricted rights to enter at will, treated the same as home folks.
So it wasn't contrary to their will.
Exactly. The entrance was not contrary to the will of the occupier, and the servant exception does not apply, so this element fails.
And after analyzing all the elements, what was the court's final conclusion?
The court ultimately held that because her entry was fully authorized and not contrary to the occupier's will, there was no breaking. They reversed the conviction entirely.
Wow. So she just gets away with burglary.
Yeah, she does. The court refused to establish a new doctrine of constructive burglary for voluntary entries.
I mean, she still stole the money, though.
True, but the court noted that in 1922, burglary could be punished with death. So in favorum vitae, meaning in favor of life, they refused to stretch the law.
That makes a lot of sense when lives are on the line.
Interestingly, they reversed the judgment on the substantive ground, even though it hadn't even been raised in the lower court.
That is incredible. Okay, I want to propose a really visceral, unforgettable hypothetical to test the boundaries of this occupier's will and the servant exception.
All right, let's hear it.
Imagine you have a roommate, and their eccentric best friend is given a key and told, "Mi casa es su casa. Come over day or night."
Okay, totally unrestricted access.
Right. And this friend uses the key at 2 a.m., walking in specifically to steal your prized, highly valuable collection of preserved vintage toenail clippings.
Oh, wow. That is gross.
Very gross. But does this gross theft constitute burglary?
Despite the bizarre and totally felonious intent to steal the clippings, the friend has unrestricted consent to enter.
Because of the mi casa, su casa thing.
Exactly. They are not a servant. They are treated as home folks. Therefore, the entrance is not contrary to the occupier's will. No burglary.
Okay, let me push back with a modification.
Huh?
What if, instead of best friend, the person entering at 2 a.m. to steal the toenail clippings is the house cleaner, who is given a key solely for the purpose of cleaning on Tuesdays?
Ah, now that changes things completely. The house cleaner is a servant or employee with a bare charge of the premises.
Meaning they don't have full possession.
Right, they don't have unlimited free will to enter. Because they entered with a previously formed design to commit a felony, stealing the clippings, modern authorities hold that this is a breaking. Yes, this constitutes burglary.
That's such a fascinating distinction.
Yes.
So can you distill this intricate legal reasoning into a practical framework for the listener?
I'd be happy to. Here is a step-by-step diagnostic checklist for exam taking and issue spotting.
Great.
Step 1, identify if there was an entrance. Step 2, check for constructive breaking. Was the entry obtained by threat of violence, fraud, or conspiracy?
Got it.
Step 3, check for actual breaking. Was any physical force used, even just turning a key or lifting a latch?
Goes really low bar.
Very low.
Yeah.
Then step 4, the critical filter, evaluate the occupier's will. Was the entry contrary to the voluntary consent of the owner? If they had unrestricted access, the breaking element fails.
And the last step.
Step 5, the exception check. If the entrant had permission, determine their status. Were they an intimate friend, which means no burglary? Or a servant with mere bare charge who entered with a premeditated design to commit a felony, which means burglary, applies.
Thank you so much for that rigorous breakdown. It really makes it clear. And I want to leave you, the listener, with a final provocative thought to mull over.
Yeah, what's that?
Well, The court in Davis drew a hard line between a friend with a key and a servant with a key, right? But think about today's gig economy.
Oh, that's a good point.
Dog walkers, house sitters, delivery drivers, they regularly have digital access codes to our homes. Where exactly is the line between a companion and a caretaker now?
It's super blurry.
Yeah, if you give someone a passcode, are you giving them bare charge or are you treating them like home folks? It really leaves you to consider how a 1922 doctrine applies to the modern threshold of your own front door.
Definitely something to think about.
Until next time on The Deep Dive.